This case may sound procedural on paper, but don't let the calm tone fool you. The stakes here are massive. We're looking at a defendant facing aggravated assault with a deadly weapon, a second-degree felony in Texas, carrying a possible sentence of up to 20 years in prison. And what makes this hearing so intense is that everything hinges on one decision: whether the court trusts this defendant enough to grant deferred adjudication, or whether this plea deal still leaves him staring down serious prison time. You'll hear a lot of yes ma'am and yes, Your Honor, but behind those answers is a defendant waiving core constitutional rights: the right to a jury trial, the right to confront witnesses, and the right to remain silent. Once those are gone, there's no rewind button. Then comes the twist. Despite a plea bargain, the state opposes deferred adjudication, and the judge starts digging into this defendant's history: missed court dates, GPS violations, and compliance. It's just stick with this case, because by the end, one request changes everything. And the answer isn't what the defense hoped for.
Court will find that the state is in compliance with discovery. Mr. Manning, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Your Honor, the state's proceeding on count one, and we are going to strike.
I'm sorry, you're proceeding on count 1 and?
For waiving counsel.
All right, any objection?
No objections, Your Honor.
And Ms. Abrams, this is going to need a PSI as well. All right, Mr. Manning, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on count 1, which is an aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury?
This is a critical legal moment, and it's easy to miss if you don't know what to listen for. The judge carefully explains the range of punishment: 2 to 20 years and up to a $10,000 fine, and makes something very clear. The court is not bound by the plea agreement. That means even if the defendant and the state agree on terms, the judge can still reject parts of it. Deferred adjudication is not a free pass. It's conditional mercy. If granted and later revoked, the court can sentence the defendant to anywhere within the full punishment range, not just the plea deal number. That's why these questions matter so much. They protect the record and prevent appeals later. Viewer question: if you were facing up to 20 years, would you risk deferred adjudication knowing one violation could land you in prison for decades? This is the moment where the defendant locks himself into that gamble.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Manning, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 1. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. State opposes your application for deferred adjudication. All right, Mr. State, do you have any evidence to support the defendant's plea?
Yes, Your Honor. The state moves to admit was in order to see Exhibit 1 and all attachments.
Any objection?
No objections, Your Honor.
Mr. Manning, I'm showing you what's entitled waiver and
Here's where the
consent.
case shifts from punishment to evaluation. The judge finds sufficient evidence to support guilt, but defers the finding, ordering a PSI report, along with substance abuse and mental health evaluations. This tells us that court isn't done deciding this defendant's fate. A PSI, or pre-sentence investigation, is huge. It examines criminal history, personal background, mental health, substance use, and risk to the community. Judges rely heavily on it when deciding whether probation, deferred adjudication, or prison is appropriate. What's interesting is the judge's skepticism. She notes that nothing in the file initially indicated mental health issues, but still allows evaluations to be on the safe side. That signals caution, not leniency. The court is gathering data, not making promises. This is the calm before the storm, because the final decision hasn't been made yet.
Health issues that need to be addressed through the CHOP evaluation?
Yes, Your Honor, I believe there might be some mental health issues.
All right, because based upon reading this, I didn't see anything that indicated that. Mr. Manning,
Yes,
have you ever been diagnosed?
with more so emotional as opposed to mental. And by that, I mean, depression.
All right, we'll do a MIC evaluation. So probation, it'll be a TAP evaluation, a MIC evaluation. Of course, we'll lead the PSI report.
Yes, Your Honor.
And that'll be while in custody. Defense, do you anticipate calling any witnesses?
Not at this point, Your Honor.
State.
Possibly the complaint, Your Honor, we can talk to them about that.
All right, so only one witness potentially?
We've been
We'll have one witness until we.
All right, so we're going to be back on September 29th at 9 a.m. Please have your witnesses here. And the court will make a decision on your application based upon the PSI report and any other evidence that's submitted to me. Do you understand?
Your Honor, excuse me, my client was asking if you could set a PR bond until sentencing.
No.
Got a daughter that's he hasn't seen for a while. And she has,
That was part of the reason was so that I can move forward with my daughter's life. Is the reason I had taken this plea bargain.
No. Here's the thing. I show that you entered the plea freely and voluntarily. You informed the court that there was.
This is where reality hits. The defense asks for a PR bond, essentially asking the court to trust the defendant to remain free until sentencing. The judge doesn't hesitate. She points to prior GPS violations and a failure to appear in court. Those aren't technical issues, those are trust breakers. The judge makes it clear. We are where we are because of the defendant's own actions. Even explanations, even dramatic ones, don't change the court's role. Judges don't investigate stories from the podium. They rule based on records, compliance, and credibility. The bond request is denied. Custody continues, and the final decision will come only after the PSI and evaluations are complete. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.